Thank you all for coming this afternoon to hear my little talk on environmental constitutionalism, sometimes called constitutional environmentalism. Scholars attach great significance to the different formulations of it, but the core of what I'm going to talk about today relates to the use of a constitution to further environmental values and some peculiarities to dealing with environmental rights at the level of a constitution, and I'm going to move towards ultimately some draft provisions that we've worked on for potential inclusion in a Scottish constitution that will address environmental issues. I have to acknowledge first off that I am an attorney from Austin, Texas, and I'm an environmental attorney, and I work in the areas of urban planning and environmental protection. And Texas sometimes gets a bad rap, fairly so, I think, when it comes to environmental issues, and so I have to have my first slide be the cherished Barton Springs, which is a sign of kind of Austin, Texas, and how deeply we care about the environment and about natural settings. But with that in mind, I'll just dive in. What I'm going to talk about this afternoon is constitutional environmental rights, the history, theory, and practice of how environmental rights have been addressed at the level of a constitution. I'm going to talk briefly about Scottish environmental and land management issues, and then I'm going to move, as I mentioned, to looking at some draft constitutional provisions that try to wrap themselves around some of the issues that I'm going to talk about. So I guess first off, the question is why constitutionalize environmental rights? Why address environmental rights at the level of a constitution? And I think, as Mark mentioned earlier, the idea of a constitution is somewhat new, I think, to a lot of Scottish citizens who have functioned, arguably quite effectively before without a constitution. But a constitution is a very important document. And it deals with taking things out of the political process, or at least making it much harder to mucky with an issue through the political process and putting it on a higher plane, a higher level that seeks to remove it from the whims of public opinion and from the whims of the political process. Environmental issues are extremely important. The environment, the rights that a constitution traditionally protects, freedom of speech, freedom from unlawful arrest, freedom from being unreasonably searched, those sorts of rights that we all think about when we think about a constitution will mean nothing if we can't breathe the air, will mean nothing if we can't drink the water, will mean nothing if the planet warms to the point where it can't support agriculture or even potentially human life. On this latter problem, global warming or climate change has elevated the importance of environmental issues, I think, in the minds of people all over the world. And efforts have so far failed to reduce greenhouse gases. The efforts that countries have taken around the world have so far failed to reduce greenhouse gas emissions to a level that's deemed necessary to keep global warming at a level of below 2 degrees Celsius. And if we go above that number, there's definitely some uncertainties as to what'll happen, but it's clear that it's going to be really bad. And the effects will vary significantly from region to region. But in Scotland in particular, the effects of global warming at a level above 2 degrees Celsius by the 2080s are likely to be on par with the overall trends that are expected with global warming. And that can mean drier summers, wetter winters, a 50% reduction in snowfall, increases in storms, floods, and droughts. And as the temperature rises and as the effect of that change is felt over a longer period of time, the worst case scenarios do not bear well for Scotland or for humanity at large. So given the significance of the environment to our way of life and to the realization of other rights, it's natural that people want to address environmental rights at the level of a constitution. The Constitution is where you put things that are the very most important to you as a society. And so there has been a movement, as I'll talk about here in a minute, around the world over the last several decades to address environmental issues at the level of a constitution. International law, in general, does not currently provide a fundamental right to a quality environment. And many of the actions that are going to be required to meaningfully address climate change require international action. One nation acting alone or nations acting in a piecemeal fashion are not going to be able to meaningfully affect the problem. But it has to start somewhere. And international law develops over time by individual states across the planet taking action. And so to elevate the level of environmental issues to the point where they could potentially be adopted as a planetary right is going to take action by individual states. It needs to be said, though, that environmental rights in some ways are very different than the kinds of rights that are traditionally protected in a constitution, and those differences present conceptual and potentially legal difficulties to the realization of constitutional rights to a healthy environment. They're not rights against the state nearly as much as they are a right to have the state take action to halt the harmful actions of private parties. So, generally, very common constitutional rights are rights to not have police officers, bust into your apartment without a warrant. Rights against the state to your individual freedoms. Environmental rights are rights that are really accrue to society as a collective. And so they present certain conceptual difficulties when they're compared to other types of rights. It's difficult for judges to apply because of the technical nature of environmental issues. We can all agree in certain broad conceptual terms to the importance of environmental rights, to the issues around global warming, but when you get into the specifics of development and growth and the kinds of things that have led to global warming, when an action is going to cross the line in terms of emissions or whatever, they're very technical sorts of issues. And so to embed those rights into a constitution and then potentially have litigation in front of a judge around those issues presents some difficulties. Constitutional environmental rights also challenge, to some extent, the concept of standing. And standing is a legal concept that's present in a lot of different constitutional systems, and it's a constitutional concept. And in general, it varies across the world as to what the requirement for standing is, but generally speaking, a person doesn't have standing to bring a lawsuit against the government unless they can show a particular harm to themselves, not a generalized harm to society as a whole. Courts are generally ill-equipped to deal with large societal problems. They're meant to deal with problems that affect particular parties to a case. And environmental rights are a different animal. And so the realization of environmental rights and the protection of environmental rights in a constitution requires a broader concept of standing than many nations around the world have so far been willing to consider. The first recognition of, the first sort of acknowledgement of the need to protect the environment at the level of a constitution, although she doesn't use the word constitution, is attributed to Rachel Carson. And Rachel Carson was an activist from the United States who was instrumental in getting DDT banned. And she was an impassioned activist as well as a biologist. And she said that if the Bill of Rights, referring to the United States Constitution, contains no guarantees that a citizen shall be secure against lethal poisons distributed either by private individuals or by public officials, it is surely only because our forefathers, despite their considerable wisdom and foresight, could conceive of no such problem. And that's with a lot of the legacy constitutions that have been around for a long time, including the United States Constitution. They were drafted at a time before industrialization and before we became aware of the consequence of human development on the environment. The first formal recognition by a governmental or international body of the need for environmental protection was the Stockholm Declaration, that was a declaration of the United Nations Conference on the Environment. And it read, "Man has the fundamental right to freedom, equality, and adequate conditions of life in an environment of equality that permits a life of dignity and well-being, and he bears a solemn responsibility to protect and improve the environment for present and future declarations." Concurrent with the adoption of this declaration, the United Nations Conference on the Environment also adopted a resolution that encouraged nations around the world to embed environmental rights into their national constitutions. Since the Stockholm Declaration, which was kind of a turning point for thinking about environmental rights, there have been about 130 countries that have adopted constitutional norms of some kind dealing with the environment. Portugal and Spain were the first, and they adopted their environmental rights provisions in the 1970s. And they have grown more rapidly. Environmental rights have grown more rapidly than any other human right over the last 50 years. I want to talk briefly about the types of environmental rights that exist under different constitutional schemes. The first, and I think the most important one, and the one that's easiest to relate to, is a substantive right. A constitutional provision that guarantees citizens a right to a healthy environment. That right is supposed to be self-executing in the sense that by conferring an absolute right, it gives citizens the authority and the standing, if you will, to bring actions against their government, holding them accountable to what is the government doing to guarantee that right that is granted to citizens in a constitution. Policy directives. Constitutions will sometimes fall short of guaranteeing an absolute right, but they will express a strong statement of policy, a strong statement of that this is what our society values the environment. Policy directives, although they're not a substantive environmental right, they serve to inform subsequent adoption of legislation, and they often have significant effects. Procedural rights, as related to the environment, deal with a transparent process. They deal with access to information. They deal with requiring government officials to come clean about the environmental effects of projects, development projects they're approving, and actions that they're taking. Procedural rights are very important. A lot of environmental consequences of government action in terms of the environment are sometimes shielded from the citizens. And without the ability to know what's going on and what the consequences of actions are, there's much less likely to be a demand for government to act differently. Also, as I believe Mark mentioned at the beginning of today's proceedings, there's a need for fairness in decision-making with respect to the environment. And another example of a procedural right is having in a constitution requirements that regulating bodies, regulating agencies be shielded legally from influence by the entities that they're regulating. The United States, I think, is a poster child as to what can happen when you don't have those sorts of protections in place. You have regulators working for an agency making decisions that are very favorable to the entities that they're supposed to be regulating, and then lo and behold, they leave the agency, and who do they go work for? The companies that they were regulating. And so procedural rights can serve to enact some protections against that occurring. Derivative rights there are a lot of constitutions that, although they don't expressly mention the environment, courts have found that have derived environmental protection from rights that are mentioned. There are constitutions that mention a right to life, and there are many courts around the world who have discerned or inferred from those sorts of broad rights a right to a quality environment. So, with, as I mentioned, approximately 130 countries around the world have adopted some sort of environmental protection rights in their constitutions. What have the practical effects of that been? It's hard to assess with great particularity what the results of that have been, but the trends overall are unmistakably positive. And I'll go through just a few of the examples, I think, that back up that conclusion. Constitutional rights to an environment have had the effect of encouraging stronger environmental laws. When you have a constitutional mandate to guarantee a right to a quality environment, that lights a fire, if you will, underneath politicians who may otherwise lack the political will or the political ability to adopt stringent environmental regulations. And when there's a constitutional mandate on the books to guarantee environmental rights, it becomes easier in a political context to advance and advocate for stringent, strict environmental regulations. Argentina, Portugal, Costa Rica, Brazil, Colombia, South Africa, Philippines. Those are all countries where stricter environmental laws have been adopted in response, in part, to the protection of environmental rights in the Constitution. They prevent rollbacks. If you enact a constitutional right to a quality environment, one of the, there's a lot of, as I mentioned earlier, it's sometimes hard for courts to tell, well, when is that right violated? These issues are so complicated, it's not always clear when a right to a quality environment is being violated. But a good baseline is that at the time you adopt that right, you better not weaken any rules. Like, once you adopt that right, you're establishing a baseline that, okay, we're not going to go backwards on our environmental protection. And so countries that have adopted environmental rights provisions, courts have found that in legal challenges that governments don't have the constitutional authority to roll back environmental regulations. And that's an important point. As I mentioned earlier, one of the purposes of a constitution is to take the issues that are very most important to a society and remove them a little bit from the whims and of the political process. Increased enforcement. With a constitutional right to a healthy environment on the books, there has been many examples around the world of governments more strenuously enforcing the rules that are on the books and going after companies that are polluting and things like that. And there are really three aspects to environmental rights in a constitution. Government can't infringe the environmental rights. They have to protect against private parties violating those rights, and they can do that through regulation and enforcement. And they have to take action to fulfill those rights. And that can come in the form of public works projects and projects that mitigate the impacts of human development on water. And additionally, when I talk about environmental rights, I tend to think, because I live in an area where I have clean drinking water, I have reasonably clean air to breathe, and I'm not worried about the day-to-day immediate effects on the environment on my life, I tend to think more about big issues like global warming and things that affect the whole planet. But a lot of the people that live in places where environmental rights have been constitutionalized don't have clean drinking water. They don't have some of the basic amenities that a lot of us in the developed world take for granted. And constitutional rights provisions have been used as the basis for lawsuits that have forced governments to provide clean water to people. I think it's estimated that in Brazil or Argentina, I can't remember which, I think it was Brazil, there are potentially millions in Brazil that enjoy clean drinking water because of services that were provided by the government to fulfill the constitutional mandate to a healthy environment. There have also been significant lawsuits. In Argentina, there was a case brought shortly after they adopted their right to a healthy environment that cleaned up the Matanza-Richello watershed. And although that cleanup is still underway, without that constitutional right to a healthy environment on the books, there would have been no basis to hold them to account to clean up that area of the world. Constitutional environmental rights also level the playing field by not letting other rights, such as property rights, trump the environment. A lot of times, environmental protection, the goals of a healthy environment, force people to give up, to make sacrifices. It forces people that want to build and develop land to do so in a manner, to do maybe a little bit less of it than they want to do, and to do it in a manner that's going to cost a little bit more. And a lot of constitutions, appropriately so, include provisions for protecting property rights. And one of the issues, and we've seen this a lot in the United States, is that when local governments or state governments or the federal government has attempted to impose restrictions, there are cases where the environmental values underlying those restrictions have had to yield to the rights for private property use that are embedded in constitutions. And so by acknowledging in a constitution that environment is a fundamental right, it prevents other rights from automatically trumping that. So I want to talk now about issues and opportunities for Scotland. And I think it first has to be acknowledged that Scotland has environmental consciousness deeply ingrained in its civic life. Shortly after the adoption of Home Rule in 1999, Sam Galbraith, the newly installed Environment Minister, declared a commitment to incorporating the concept of sustainability, social and environmental sustainability, into all government decisions. And even before Home Rule, in 1991, the term sustainability made its first appearance in any law anywhere in the Scottish Natural Heritage Act. And in 2009, about 10 years after the institution of Home Rule, the Scottish Climate Change Act was adopted. And it's the most aggressive attempt to regulate greenhouse gases and require use of renewable energy of any nation anywhere. And the Climate Change Act aims to cut greenhouse gases by 80% from pre-industrial levels by 2050, and have 100% use of renewable energies by 2020. The land ownership issues, I mentioned part of my presentation and part of the constitutional provisions that I'm going to get to here in just a minute. Besides dealing with the environment, they deal with kind of land management and land ownership issues. And those issues, in what I've studied in terms of how the environment is discussed in Scotland, those two issues are often intertwined. They're very distinct, but they do intertwine. And sustainability, the concept of sustainability, is about more than the environment. It reflects a larger egalitarian sensibility that includes social and economic goals as well as environmental ones. And with that in mind, Scotland has the most concentrated patterns of land ownership in the developed world. Half of the country's land is owned by 608 people, and 10% is owned by 18 people. That's unlike anywhere else in the world. And the reasons for this are complex, and they're beyond the scope of what I'm certainly prepared to address this afternoon. The environmental impacts of concentrated land ownership may not always be bad. A lot of, the right to build on land doesn't automatically accrue with ownership. In Scotland, Scotland already has very restrictive rules for developing land. So just because you own it doesn't mean you're going to be able to build horrible things on it. And a lot of the land that is owned by tiny groups of people, they've accepted that they're not going to be able to do a lot with that. And so there's a lot of land that's owned by a small group of people that seems to remain undeveloped. And so there's not a clear one way or the other how breaking up that ownership pattern would affect the environment. Rural areas are sparsely populated, and they make up about 89% of Scottish land. The population, the rural lands in Scotland are among the most undeveloped and pristine in the EU. And overall, the Scottish population is a very urbanized one. They live in areas where there are services, where there's a greater walkability, a greater use of mass transit, and there's less population sprawl that we find definitely in the United States and increasingly in other areas of Europe as well. So despite the complexities, though, of sort of the ownership issue and the pros and cons of it and the complex social injustices that I think historically have led to the state of affairs we have now with land ownership, there exists a strong sense that something has to be done. And one of the most obvious steps that can be taken to at least make that possible is to create a better land registry. Currently, it's very difficult in Scotland because of the poorly kept records to know who owns what. There's almost no regulation on the sale of land in terms of reporting what's being sold, reporting who owns it. There's a great deal of offshore landowners, and this prevents the government from knowing what's out there. It prevents them, even if they had the authority, from doing condemnation, and it prevents developing a full tax base that could potentially help to fund the kind of projects that could really address some of the environmental goals that I've been talking about. So with all those issues in mind, I want to turn to a few provisions that are in the draft Constitution that are available on Newsnet. The first proposal is an actual substantive right. As I mentioned, this is the strongest type of right that a Constitution can provide with respect to the environment.
Could you clarify that? Newsnet, the website?
Yeah, it's on the news website. There's a little rubric where you can click on it. A Constitution for a Modern Scotland. It's on the front page. So.
The Scottish government shall pass no laws infringing upon and shall develop laws to guarantee the following rights: the right to a healthful environment, including clean air and water and a climate hospitable to life and supportive of agriculture. Provisions shall be made by law to protect the environment for the benefit of all present and future generations, and for restrictions on the development of land and natural resources in furtherance of this clause. It's a substantive right. It guarantees citizens a right to a healthy environment, and it requires state action in furtherance of that right. Proposal for a complete and transparent land registry. The totality of the territory, buildings, and other goods within its land and territorial waters require legal title in Scotland and shall be registered and taxed exclusively with the Scottish government. Complete transparency on ownership is required for the bearer to register and maintain title. Goods for which legal title cannot be legitimately established shall revert to public ownership.
I did add it to a latter one, legitimately established by law. I added that later because I think there was some questions about the ambiguity of that.
It's an evolving document. But the last sentence, goods for which legal title cannot be legitimately established shall revert to public ownership, even with the little change that Mark indicated. The intent for that is to get landowners to come clean and acknowledge what they own and register it. And if they don't do that, they risk losing their land. And a lot of this provision in particular, it would require subsequent legislation to work out the details and the timelines and all of that, but its intent is clear. And this is more of a summary of other provisions related to the environment that appear in the draft Constitution. But it requires peer-reviewed regulation to further the substantive environmental rights. A lot of times, sometimes in the United States, local governments or potentially state or the federal government may gravitate towards science that is of questionable repute. And so in order to avoid kind of result-oriented cherry picking of scientific studies, there's a requirement that regulations be based upon peer-reviewed, best available science. Prohibits spot regulation that exempts particular areas. The regulations adopted for the environment need to apply to the country as a whole. And certainly there are going to be regulations that by their very nature affect certain types of land features and not others. But carving out particular areas that are owned by friends of the right people or what have you would not be allowed under this draft. It requires rigid and uniform enforcement, and it requires actual fairness and the appearance thereof. Sometimes a regulation can be fair or be adopted with the purest of motives, but if the process surrounding the adoption of that regulation includes a lot of the appearance of backroom dealing and the lack of transparency that I spoke about earlier, the sense on the part of the people that they're getting a fair deal and that the government is dealing in an even-handed manner with them can be greatly compromised. And so the Constitution requires that there be absolute fairness and transparency. So these provisions, simply putting these in a Constitution does not make it so by any means. But for reasons I tried to explain earlier, the record so far is that when countries do codify environmental rights into their constitution, it ups the ante. It ups the ante on the part of legislators to adopt better laws. It ups the ante on the part of regulative bodies to enforce more strictly. And it creates a political imperative to move forward and to take the environment seriously. Even when doing so sometimes may butt up against other societal values and potentially other rights as well. And if Scotland does opt to be independent, I think that adopting provisions along the lines of what I've described today would enable it to fully rise to its great commitment to the environment that has been expressed in so many different ways over the last several decades. So with that, I have nothing further.